see. I believe this is Frank Stevens. Is that Frank Stevens?
Yes, Your Honor.
Okay. Who's in the jail?
Oh.
Might be your sentencing at 8:30.
Well, I'm trying to figure out who's in STF and the MDOC jail.
That I believe, Your Honor, is the, I learned yesterday that I believe is the victim on the matter. It's 22-02170 FY, People v. Bird. I learned yesterday he was an MDOC, so we did a video writ. I would just like to speak with him briefly, if possible.
Okay, the person in STF?
I'm not sure if that's him or not.
What's the name you're looking for?
Luis Perez Revolta.
Who's in STF?
I'm here.
What's your name?
Luis Perez Ribalta.
That's him, okay. Hang tight. When the prosecutor's available, we'll get you in the meeting room with him.
Okay.
And then I think this is Gautama Haptalem.
Yeah, yes, Your Honor.
Okay, and Mr. Nichols representing him, is that correct? Or is someone filling in for Mr. Nichols? Do we know if Mr. Nichols is here today?
I haven't seen him yet.
Can you go find Mr. Nichols for me, please?
Are we talking about Scott Nickel?
I assume.
Okay.
Let's see.
I can go take a wander in the hall, but try to find him.
He can do it. I'm gonna do your, you have a, oh, did your guy appear?
No.
Vincent Forrest? Okay, I'll do a picture one.
Okay, we don't need to go on the record to that.
No, he felt okay, you're fine.
Thank you.
Thank you.
Judge, what was the name of Mr. Nichols?
Haptalem is the last name, Habtalem. It looks like he was already in your studies. On this file. The client was already in warrant status, actually.
Yeah, yes, ma'am. I know he was. He failed to do the CSI.
Sounds good. Thank you.
I don't think he was in warrant status on this one.
He was not. Okay, on the record, in the matter of Kenyon Lanier versus, I mean, people would say the Michigan versus Kenyon Lanier, file number 23-03389, counsel appearance.
Jeff Prado, it's on behalf of the people, Your Honor.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Lanier, who is present and to my right.
Okay, you're Mr. Lanier?
Yes, ma'am.
Okay, today's the date that was set for a preliminary examination. Are we continuing to examine today?
At this time, Your Honor, I believe the parties would be asking for an adjournment. Mr. Yang did make a request from the prosecutor's office for the body cam dash cam N911 call in this matter that had not been shared with our office. So I made a request through our discovery department. We have requested that from LPD. We are just waiting for LPD to share that discovery with us so we can share it with Mr. Yang.
Okay, so
That's a fair and accurate statement. I have requested it as back on November 14th. I understand there was a holiday there and now. I'll just ask, I guess I'll just like to inform the court that I have requested it. It's been a few weeks, have not received it. But I think it's important for me to review that before we decide to move forward.
okay, sounds good. Okay, and Mr. Lanier, do you understand what's going on at this time? Are these transitional lenses?
Oh, no.
You wearing sunglasses in court?
I mean, yeah.
It's raining outside. We're in a building. You understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned. You understand that? Okay, and so due to the fact that your attorney is seeking some additional discovery to help formulate your defense, that being the body cam video, are you willing to waive the timeline so that we can reset this beyond the 21 days? Anybody, you gotta say it so the record can hear.
Yes, ma'am.
Anybody threatening you?
No, ma'am.
Did you do that? Any promises being made?
No, ma'am.
Okay,
January 11th at 9:30.
January 11th at 9:30. Okay? Does
Yes,
that
ma'am.
work for you, Mr. Yang?
Check my calendar.
Yes, that works, Your Honor.
Okay, we'll get you a copy of your notice to appear. Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Thank you, you're all set.
Sign it, Mr. Nickel.
Yeah, it's good to sign.
I think one of his colleagues just tried to message him, I believe. On the record in the matter of the people of the state of Michigan versus Joyce Martin, file number 19-04357. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Morning, Your Honor. Attorney Derek S. Ross, public defender on behalf of Ms. Martin. Ms. Martin is in the courtroom standing to my right.
Okay, how are you, Ms. Martin? Today's the date that was set for sentencing. You have a pre-sentence report and recommendation. It was prepared 29th, so very recently. Did you get a copy of that?
Yes, Your Honor.
Okay, any need for us to make updates, corrections, or deletions?
Your Honor, just in regards to the questionnaire it cites, they always cite that we receive and have the questionnaire to review. We never receive it, but I don't think I need it to go forward, just to let the court know I don't have that questionnaire. In terms of additions, deletions, or corrections, when I reviewed this with Ms. Martin yesterday, the only thing inside of the actual, it's actually in the assessment. It contradicts itself in a couple of places. It talks about her getting $290 cash a month as well as food stamps. And then it says $290 in food stamps. The correct thing is she gets $290 in food stamps. She does not get any cash assistance.
Any other updates that should be made or correction?
Don't believe so, Your Honor. We don't necessarily agree with the findings, but there's no additions, deletions, or corrections. The findings are whatever they are.
Findings of the pre-sentence report?
Of the assessment saying that she has issues that would lead her to have outpatient treatment. When I read it, it primarily talked about nicotine and sporadic cannabis use. She does use cannabis for her mental health medical issues, and she did get a medical marijuana card. She did show me the email where it got approved recently and should be sent to her in the mail within 7 to 10 days.
Okay, and I'm not going to get into any disagreement with the assessment because you'll be qualified to do an assessment.
Yes, Your Honor.
I know I don't have the qualifications to do a substance abuse assessment, and I don't know that you have those either. So if their assessment renders an opinion that they believe she would benefit from some treatment, I don't have anything else to rely on. That would be an assessment from somebody else that says she doesn't. And as her attorney, you could have requested that to happen. I don't have another assessment that disputes that. She can always get a second opinion. I do see where she was consistent in stating that she doesn't use cocaine. She just had it on her. But this is a situation where she's got a cocaine use now. And then, so I'm just not really. You can't plead guilty to a use and put a factual basis on for that. And then in the assessment, be adamant that she didn't do it. One of those two is not the truth.
We should not deny that she did it, Your Honor. I think the factual basis was sort of the underlying count that she had possession.
Correct, but but guilty to the use though. And in the report, she essentially reported she just had it on her, that she doesn't use it.
In the assessment, she said 4 to 5 years ago, she used it like once or twice, I believe.
Well, this incident allegedly took place about 4 years ago.
Yes, Your Honor.
So,
And there's been no additional drug crimes or any other type of criminal history in that period.
okay, you can go make your allocution at this time.
Thank you, Your Honor. Your Honor, I would ask the court to follow the recommendation for the most part. Please grant the 7411. It's my understanding she has, this is over 4 years old. She hasn't had no additional involvement with law enforcement. She had no prior criminal history. She advises me. She has received a medical marijuana card. She would ask the court to allow her to use medical marijuana in accordance with the statute. This is, as I just pointed out, a case that's over 4 years old. I asked her, well, first, I would ask the court to waive any fines, fees, or costs. The court will. She is indigent. She lives in government housing, receives food stamps, and relies on family members and friends to help support her. I asked her if she doesn't have a job, how does she intend to pay for any type of medical marijuana? She advised me that she only uses it when necessary and that her family and friends assist her getting it when she needs it. Again, based on my reading of the report, and I know the court's already ruled without a different professional report, the court is going to go with that report, but the admissions to drug use, I don't know, rise to the level of needing outpatient service. She does, and look forward to and ask the court to have her go to Northwest Initiative, though. She believes that would be beneficial to her and help her in her everyday living, establish more social contacts, and maybe help her get a job and help her with her financial situation. Regarding the recommendation, for probation, she would leave it to the court's discretion. Thank you, Your Honor.
What did you find? Was she in her own statement?
Not say anything this morning.
I don't know really what to say, but you know, whatever you see fit, that's what I'll be doing.
You can say whatever you feel like you need to say necessary. I wasn't there the day of the incident. I don't know what your perspective is as it relates to what your needs are. I have a report here, ma'am, that indicates that when you met with probation, that you were very forthcoming and you were honest, but that you mentioned that you did have an ongoing struggle with addiction. Is that your belief?
A little, but not really. Just a little back then.
You said back then to when, so the way this report is written, it would cause me to believe that this is a present issue. Were you representing a past issue to probation?
Yeah, she wrote a lot of stuff on the way she wanted to write it. Like we been getting the food stamp, she said I got cash, and I never said anything about cash at all. So a lot of stuff, I think she just put it the way she wanted to.
Okay.
When I talked to her.
Okay, maybe there was a misunderstanding, miscommunication. That we'll err on the side of that, give her the benefit of the doubt. But that's why I asked you, is there anything you wanted to say? Because this is your opportunity to clarify those things for you. So you did have, you believe you did suffer from some addiction?
Yeah.
Okay, and was that to cocaine?
Yes, ma'am.
Okay, and when's the last time you used cocaine?
Probably about a couple of years, man.
Is it 2019 or are you talking about 2020?
19 as well.
Okay, and then did you go through a course of treatment to address that?
No, I ain't got to
Okay, so how did you address the addiction?
myself.
You just quit cold turkey? Okay, and so the report does indicate that you were questioned by the probation officer about whether or not you had in place any relapse prevention plans. Or did you know what the triggers were? Because you did engage in stopping on your own and you didn't do it through a course of treatment, did you have the necessary tools to assist you should you be in a situation that triggered you to be at a place where you thought you might want to use? And that was what the concern of this officer was. I think I share in that concern. I don't know that you need to be involved in full-on outpatient programming, but I think you do need some counseling as it relates to the use of substances so that you can garner those tools so that you'll have them for you. Okay, so because you want, I don't see anything on your prior criminal history. There's nothing there. So this was your first time getting a conviction. You are eligible for a sentencing under 7411, but you would need to be on a term of probation for that, okay? Okay, so with that being said, I am going to adopt the recommendation for the most part. I'm going to sentence you to 6 months probation. While on probation, you're going to participate regularly in preliminary breath testing and urinalysis testing. I'm going to order you to do a 12-step program at Northwest. The 12-step program and the initiative program at Northwest. I'm not going to order outpatient substance abuse at this time, A, because of the age of the case. This is almost going on 5 years now since the alleged incident, and because of the things that you've shared, both to your officer. It looks like you've even shared it at the time of your assessment, and then you're sharing it with the court. And I do believe that you've addressed the use on your own. I just want to make sure that you have some tools and skills so that you don't relapse, okay? So I think that we'll start that there. If for some reason we believe during this course of probation that you may need some additional support, then we'll get you that support, okay?
All right, thank you.
You're welcome. You're not to engage in any assaultive or threatening behavior while on probation. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You will show your probation officer a copy of your medical marijuana card, okay?
Yes, ma'am.
And if you have it on you today, you can show it today so they can get a copy of the file.
I already did.
Oh, okay. You did show it today?
Show them that email thing.
You showed me,
Because I
but
get their card. Yeah, him.
you gotta show probation.
You gotta show
Oh,
probation, okay? Otherwise, if you're ordered to test and it comes up in your system, then they'll issue a violation. You don't want that.
All right.
Okay. There's a $30 per month oversight fee that you would be responsible for during probation. And you're not employed, is that correct?
Yes, Your Honor.
Oh, and why is that?
Right now, I don't have a job.
Well, I know you don't have a job. That's how you end up not employed. But why don't you have a job?
Well, I haven't been hired yet.
You've been looking?
Yes, ma'am.
Okay, so that's good that you're looking. I will note here that you're looking for employment. You're gonna be ordered to obtain employment and provide evidence of that during the course of your probation, okay?
Sure.
7411 status will be granted. There's a $30 per month oversight fee for probation. If you do 6 months of probation, that'll be $180. There's a $75 crime victim rights fee that must be assessed plus a $50 state minimum cost that also must be assessed per statute. I'm gonna waive any discretionary fines and costs. It's $305. You'll be able to make monthly payments on that. However, I recognize that finances may be an issue for you. And so I would advise that you prioritize the alcohol and the PBTs and alcohol testing that you're going to be required to do. Because there's a cost for that, okay? And so you work on making sure you get those done, because I don't want you to focus on paying the 305 and then you don't do your drops, because you'll get violated. And if you get violated for a drop, I'll issue a penalty for that. I don't penalize you for not being able to afford your monthly payment on your fines and costs, okay? And then you'll be working on getting a job, and then by then, hopefully you'll have the means to be able to pay your fines and costs. Either way, we can work on addressing that at the conclusion or the end of your probation. Last but not least, there's an advice of rights as to probation. States you have been sentenced to a term of probation in 54A District Court. Your probation conditions are individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, or stalking offense, or an offense where guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the right to request early discharge from probation once you complete half the original term ordered by the judge. The probation officer has or may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days from receipt of the notice to file any objections to your early discharge. You can make your own request for early discharge once you complete all of the required programming that I've ordered you to do, so long as you've not violated within the 3 months prior to that request. You would send a copy of your request to probation. You'd also serve a copy on the prosecuting attorney's office. The prosecuting attorney has 14 days from receipt of that request to object to your early discharge. If I set it for a hearing to address your request for early discharge, you do have the right to hire an attorney to represent you for that hearing. You don't have the right to a court-appointed counsel for that hearing, okay? Lastly, you will get that form off the court website. It's the MC 512 form, or you can just ask your probation officer to direct you to the form once you become eligible to request it. Do you have any questions about that, Ray?
No, Your Honor.
Do you have any questions about your probation status? Any additional matters for the record, counsel?
Oh, yeah, thank you.
You're all set.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Good luck to you, ma'am. You should go downstairs right now to probation and check in, okay?
All right.
Let's see what's going on here. Mr. Nickel is here. Mr. Nickel, do you need to speak to Mr. Haptalum?
Yes, Your Honor.
Let me put you in a meeting room.
Thank you.
No problem. Let's get in here and meet these people.
Is there anybody else on Zoom besides?
I'm sorry?
Is there anybody else on Zoom besides the custodies?
There are, but they don't have their videos on. Who are you looking for?
Mr. Clark.
I don't see it, Mr. Clark.
He's on there.
There he is.
Yeah.
Oh, I do see it now. It's Clark. I need to rename Absalom so I can get the right person. Mr. Palmer, who are you waiting for?
Judge, Mr. Freeman had to take off and head down to 55th for a homicide prelim, so I'm standing on Mr. Freeman's three clients.
Ravon Versa.
Yes, it would be Verser, Zudnik, and Burt.
Okay, let's see, who is? I have two people in the jail. The people in the jail, give me your names, please. What's your name again, sir, with the dreads?
Astiano Young.
Faustino Young, that's Miss Wanty's client. Does she need to speak with them? Do we know? Who's the other person in jail?
Ricky Zadovik.
That's,
Okay, do you need to speak with him at all?
I do not, my understanding is Mr. Freeman already spoke with him. We have a plan in place. There's an offer on the table, and my understanding is that this individual will be waiving his preliminary examination today, finding over to the circuit court with a plea already set for what's will happen.
Okay, let me call the case. On the record in the matter of the people of the state of Michigan versus is it Ricky Zunick, file number 23-02877, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of the defendant. I am standing in for his counsel of record, Steve Freeman, who had to leave to make.
Okay, and today was the date and the time that was set for a preliminary examination. I had a note here that we were going to treat today as another probable cause conference as negotiations were pending. And you said that there has been an offer extended.
Yes, Your Honor. It's slightly different than the offer that was initially extended, and the offer I believe that Mr. Zdunik would be waiving up on would be a plea to count 2, which I believe was controlled substance possession, specifically fentanyl. And the people would then dismiss counts upon successful plea. People would then sentence people would dismiss counts 1 and the habitual second offender notice with no objection to 7411 status, Your Honor.
That's what you understand the offer to be.
That is exactly my understanding of the offer.
Okay, Mr. Zunick, did you hear the offer?
I did hear him.
Okay, and you have the right to have a preliminary examination in the district court on the original charges. You have the right to require the prosecutor to meet their burden of establishing that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with those crimes. Are you willing to unconditionally waive your right to examination?
Yes, ma'am.
Anybody threatening you to get you to waive your exam?
No, ma'am.
Any promises being made to you if you waive your examination?
No, ma'am.
Okay, and the people waiving their exam?
Yes, Your Honor, the people would waive their right to an exam and move that this be bound over as charged to the circuit court.
Find your waiver to be freely and voluntarily made. The matter will be bound over to the circuit court. Bind over date is December 13th. That's the date the circuit court will get the file from the district court. That's not the date you need to appear in court, okay?
Yes, ma'am.
Your next court date will be in circuit court. It will be a pre-trial. Just realized that I put everything yesterday. It will be a pre-trial and your attorney will be made aware of that date, okay?
Yes, ma'am.
Do you have any questions?
Is my PR bond still like good, or do I have to wait for the court date?
No, your bond will continue. You have a bond of $1,500 personal recognizance.
Okay, thank you, Your Honor.
You're welcome. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Judge.
You're all set, sir.
Thank you.
No problem.
Judge, do you need me to sign the bind over sheet? I know we did it on the record.
No, you're fine. Did I give you a file for some files already? Because I just realized I put in. Whatever files I gave you today, I'll have yesterday's date on. Let's just do it. Which one did I do the sentencing on? It might be one.
That was his choice.
Mr. Nickel, I can bring Mr. Haptalin back.
Yes, Your Honor.
Okay. Did we see Miss Wanji? I don't know who she is. On the record in the matter of the people of the state of Michigan versus Frank Andrews Stevens, file number 22-03370, council appearance.
Luann Leverman on behalf of the people.
Don Passenger, along with Mr. Muhart on behalf of Frank Stevens.
Okay, I don't know if is Mr. Muhart still there or did he need time to come back?
He indicated that he became unstable just a few moments ago and he was on his way back in. So, but I see he's muted now, but he has been here all morning.
Okay, I don't know if he wants me to wait for him to get a stable connection.
I don't know that it's necessary, Your Honor. He just did indicate he was just kicked out again, so to speak, by the service.
Yep.
But
Okay, well, today was the date and time that we set this for an additional probable cause conference. And my understanding was that the defendant in this matter was having some medical issues, so he would not be present, and that we needed to have this date as a control date to see how we would move forward.
if I may, Your Honor, I don't believe it's actually a medical issue. He's has an outdate from federal correctional facility of September 12th, 2024. He's serving time in Colorado. So he'll be unavailable to that time. It has caused us some difficulty in being able to confer with him thus far.
Okay. That makes sense when he was highlighted in my face. Okay, he is in a federal. Is that what that's supposed to be for until when? Then for the next year?
September 12th is his projected out date at present.
Okay.
There's Mr. Muhart back, Your Honor.
Okay, Mr. Muhart, we haven't done much since you got booted out. Counsel, how do you want to proceed on this?
Mr. Muhart has been doing some work and anticipates filing a motion in the very near future. My suggestion is that we simply, perhaps 90 days out, set another status conference to assess where we are and go from there.
Okay, and the AG is okay with this?
Yes,
90
Your Honor.
day?
Yes, Your
Okay.
Honor.
We'll set it for a status conference, 90 days out.
February 29th at 8:30.
February 29th at what time?
8:30.
At 8:30.
February 29th?
That's correct. Does that work for everyone's calendar?
Yep, I was just quick pulling it up if I may. Yeah, so my cursor doesn't like me all of a sudden. There we go. 29th, 8:30 a.m. That looks good.
Okay, unless there's any other issues, we'll see you all on February 29th at 8:30.
Thank you. I'm just double checking with Mr. Muhart a minute, if I may, Your Honor.
Okay, is he frozen again? I think he is.
He sort of is, but I'm not sure he's hearing us, so he just texted me.
He's back on.
Yep, that's a good date. Thank you.
Okay, very good. Any additional matters for the record?
No, thank you.
No, Your Honor.
No, Your Honor.
Thank you. You're all set.
Thank you.
Guys, for my instability, Your Honor.
No problem. It happens.
I wish it was just Zoom. Thank you.
Thank you.
Thank you, Your Honor.
You're welcome. Okay,
That
on
was
the
a joke.
record- I know. Okay, let's see. Mr. Nickel has Mr. Haptalin. Okay, on the record in the matter of the people of the state of Michigan versus the trauma Haptalin, file number 22-02769, council appearance.
Your products on behalf of the people, Your Honor.
Assistant Public Defender Scott Nickel on behalf of Mr. Hubtellum.
Okay, Mr. Hubtellum, you can hear us clearly?
Yes, Your Honor.
Okay, today's the date and the time that's set for a sentencing. I do have a pre-sentence report and recommendation. That report was prepared on November 17th, 2023. Mr. Nickel, you got a copy of that?
Yes, Your Honor, I did receive a copy of that and I had a chance to go over it with Mr. Hubtellum.
Very good. And do we have any need to make updates, corrections, or deletions?
No, Your Honor.
You can trust the court for sentencing.
Yes, Your Honor, I did have a chance to speak to Mr. Hubtellum. He wants the court to know that while he's been in jail for these past couple of months, he has been attending CATS and AA. So he is taking some steps that he can while he's in the jail to help continue his sobriety. He does understand that sobriety is important, both long-term for him, but also keeping him out of contact with the criminal justice system. He does believe there's a good chance he should have his job, be able to return to his job. If not, he has other opportunities in landscaping and contracting he can return to. So he should be able to be employed upon his release. We're just simply asking that the court adopt that recommendation and place Mr. Hubtellum on a term of probation, order that he serve the 97 days in jail he has served to this point, and allow him to be released from custody at this time. Thank you, Your Honor.
Did you want to make a statement at all?
Your Honor, me, right?
Yes.
I just like to say, I think God has a reason for everything, and if given the opportunity to get out and be released, then I'm looking forward to the structure that I will have, and also to fulfill my responsibility to myself, to do better in this life. And I think that's really all I have to say.
Thank you. I'm happy to hear that you are participating actively in programming while you're in custody and making good use of that time. And that you are encouraged and that you are looking forward to getting on the outside to do what you say, fulfill your responsibility to yourself, but also to your community. And so I have read the pre-sentence report, the recommendation. I have reviewed your prior criminal history, which was limited, but all of the convictions are connected in that they're relative to the use or abuse of a substance. And so if you could get those issues addressed, I think that you'll find it easier for you to prosper on the outside of the jail. So what we're going to do is adopt the recommendation. I'm going to sentence you to 97 days Ingham County Jail, credit for 97 days. I'm going to put you on a term of 18 months probation. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess firearm, ammunition, or weapons of any kind. You're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You will be required to submit to random preliminary breath testing and or urinalysis testing, and you are responsible for the cost of that, okay?
Yes, ma'am.
I'm ordering you to attend a 12-step program and provide verification as directed by your probation officer. You will obtain and maintain employment and provide evidence of that to your probation officer as well. Do you have any questions so far?
No, Your Honor.
You're not to be at any bars or nightclubs while you're on probation. There's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that must be assessed. You owe $90 for the assessment and 18 months of probation with a $30 per month oversight fee is $540. Your total fines and costs will be $755 because I'll waive discretionary fines and costs, and you'll make monthly payments on that $755, okay?
Okay, yes, Your Honor.
Do you have any questions about your fines and costs or your probation at this time?
I do not.
Last but not least, there's an advice of rights as to probation. It says you've been sentenced to a term of probation before the 54A District Court. The probation conditions have been individually tailored and are specific to meet your assessed risks and needs. Except for domestic violence, criminal sex crime, stalking offenses, or offense for defense of mentally guilty but mentally ill was asserted, you may be eligible for early discharge. You have the following rights. You have the right to request early discharge from probation once you complete half the original term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice, and the prosecuting attorney would have 14 days after receipt of the notice to file written objections to early discharge. You may request an early discharge from probation after meeting the following conditions. You have completed all required programming, and you have not violated probation within the 90 days preceding your request. You must send a copy of your request to your probation officer and to the prosecuting attorney. The prosecuting attorney has 14 days from receipt of your notice to file a written objection to early discharge. If the matter is set for a hearing to address your request for early discharge, you have the right to hire or obtain your own attorney to represent you. You do not have the right to court-appointed counsel to represent you for any hearing of that nature. You may make that request by using the court's MC 512 form that's available on the court's website, or you can ask your probation officer for the form. Do you have any questions about that right?
Your Honor.
Okay. And make sure you check in with probation immediately upon your release from custody. What's your home address?
921 Blanchette Drive, East Lansing,
your phone number?
Michigan.
Very good. And your phone number?
It's gonna be different, just since I've.
Okay, so you'll update the court, you'll update probation in the court with your new number once you get it, okay?
Yes, Your Honor.
Okay, any additional matters for the record, counsel?
No, Your Honor.
Thank you. You're all set. Good luck to you, Mr. Absalom.
Thank you, Your Honor.
Thank you, Your Honor.
Is Mr. Versus still in custody, or is he downstairs? He must be in person. Because it wasn't exam. Are you you're gonna represent person?
Yeah.
He should be in custody. Okay, can we have him brought up, please? Is Keith Warren here?
Yes, he is. He's up there. Good morning. This one.
Oh, I just put her in a private meeting room. You ready with your client?
I am.
Okay, on the record in the matter of the people of the state of Michigan versus Amadius Clark, file number 23-03550, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender for Mr. Clark.
Okay, Mr. Clark is present via Zoom. Today was the date set for probable cause conference. Are we continuing to examine this?
Yes, Judge.
Okay, I have that we're continuing to examine on December 7th at 9:30 in the morning in person at the court. Was there an offer at all?
There was not, Your Honor. The offer would be to plea as charged, and the people in this case would have an objection to hide the status if sought.
Okay, and Mr. Clark, do you have any questions?
No, Your Honor.
Okay. We'll see you in person next week for your exam. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set, Mr. Clark.
Thank you.
You're welcome. On the record, Mr. Coon stepped out. Let's see, can we get this, actually, let's do this one. On the record in the matter of the people of the state of Michigan versus Keith Lauren, file number 23-03379. Council appearance.
Jeff Bradowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Wilkes on behalf of Mr. Warren. Mr. Warren is present. I'm about to be standing to my right.
Okay, today was the date set for a preliminary examination. Want to start with the dangerous weapon? Are we continuing to exam today?
I believe we are, Your Honor.
It is my understanding.
Okay. Any matters we need to address before we call our witnesses?
Nothing from the people, Your Honor.
Nothing from the defense.
Okay, you can have a seat back there. We'll call you in just a moment. I need to clear some other people out of the courtroom. You're welcome. Someone's gonna bring up Bursar. Okay, and then Bert is in custody too. Are we running Bert?
No, Your Honor, I believe that's going to be a plea.
Okay.
Like I said, I just needed to speak with the victim briefly before we go on the record with that.
Okay, you can go do that now because I have an AG case here.
All right. Already in. Sorry.
Judge, I'll be handling Miss Burt as well, but if it's all right, I'm gonna step across the hall. I have a couple of matters with Judge Flores.
Thank you, John. She's in custody, so I'll do some other ones.
I appreciate it.
No problem. Let's see. Mr. Brado, let's go to room 1. And STF. On the record in the matter of the people of the state of Michigan versus Brandon Scott Craybill, file number 23-03160. Council appearance.
Christy Berta from the Attorney General's Office for the People. The
Okay,
defendant
Mr.
is
Craybill.
representing himself.
Okay, Mr. Craybill, present via Zoom. Today was the date that we set this so that the payments that was made on the past due support amount could catch up, and the bond sheet was signed and applied. Is the defendant not at a zero balance still?
Your Honor, I don't know why the bond has not yet been transferred over to front of the court, but as of this morning, it has not yet been transferred. We have not received a copy of the signed order, so perhaps it is still stuck at the clerk's office. And then, of course, today, the next monthly charge will occur. So it is not yet at zero, Your Honor. So I have, would be asking the court, we're certainly not rescinding the offer of dismissal upon getting to zero, but we would ask the court for an adjournment to allow that to occur.
Okay, yeah, it looks like our office, I signed this on the 15th of November, notwithstanding the fact that there was a holiday last week. It should have been received over there, but I could understand why it may have been caught up in the system. I know our clerk's office has been delayed in processing because of the amount of people out because of the holiday. So
I understand, Your Honor.
They had the same issue.
I would ask the court to perhaps adjourn it to the end of December, if the court would allow. Perhaps December 28th.
Does that date work for us?
We can do 9:30.
December 28th at 9:30.
Thank you, Your Honor.
No problem. Do you have any questions, Mr. Craybill?
No, thank you, Your Honor.
No problem. You're all set for today.
Thank you.
Thank you.
No problem. Just waiting for Mr. Rodowitz to come back. Let's see. Ms. Donnelly, your matter is going to be a waiver.
Yes, Your Honor.
Mr. Coops. Is in custody. Once Mr. Rodowitz is back, I'll call yours next, Ms. Donnelly. Okay, on the record, in the matter of the people of the state of Michigan versus, can you pronounce your first name for me, sir? Wyvon versus Verser, file number 23-03387, council appearance.
Jeff Radowitz on behalf of the people, Your Honor.
And thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Verser, the gentleman who's seated tonight.
Okay, today was the date and the time that was set for a preliminary examination. My understanding is that the parties are unconditionally waiving exam. Is that correct?
Yes, that is correct. Well, that is correct, Your Honor. The people would be also moving, and we have let the defense know this. The people would be moving to add a count 5 that we would ask it be found over on as well. Your
What's the count 5?
The count 5 would be another count of a weapons felony firearm. And that would be the underlying charge on that, Your Honor, would be the felon in possession.
Okay, and I assume Mr. Palmer, either you or Mr. Freeman was already aware of that, correct?
That's correct, Your Honor. I was made aware by Mr. Freeman, who I'm covering for today, that there was no objection to adding a felony firearm. My understanding is that Mr. Verser is waiving his preliminary examination today. Once this matter reaches the circuit court, he would be pleading to this new added count 5 with the dismissal of counts 1, 2, 3, and 4.
The offer, Your Honor, was to plead to an added count, and this was gone over with Mr. Freeman. I apologize. It wasn't communicated. Mr. Palmer was to plead to the added count 5 felony firearm and an added count 6 of possession of the narcotic schedule 1, 2, 3, 1, 2, or 3. 1, 2, and 3, except cocaine, marijuana, methamphetamine, ecstasy, or cocaine. The plea offer was to plead to that count 5 and the added count 6 of possession.
Well, I guess I'm a little bit confused, Judge, then, because first of all, Mr. Verser is telling me that he was under the impression that there was only an added count 5. Second of all, if I understood it correctly, we only were just asked for an added count 5. But I don't know how we plead to an added count 6 if there's no request to add a count 6.
Correct. You only asked to add a count 5. I do see an email where you sent on the 20th to Mr. Freeman an offer indicating that the offer was that if the defendant wishes to run or waive the exam, you'll be seeking to add a count 5 felony firearm with count 3 felon in possession as the underlying charge. With that, the offer for Mr. Verser would be to plead to added count 6. But you never mentioned anything about an added count 6. So what is count 6?
We would not be seeking bind over on the added count 6. The plea up in circuit court, the plea offer available in circuit court would be to plea to the count 5 that would be bound over on, Your Honor, and then a count 6 possession. People would then dismiss counts 1, 2, 3, and 4.
So there is no added count 6, just so we're clear.
Not for bind over, Your Honor.
Okay, your email says whether Mr. Verser runs or waives, it mentions a count 6. So that's the confusion, I think.
That may be, Your Honor.
If he runs, you were gonna add a count 6?
No, if he ran, we were looking just to add the count 5 on bind over, Your Honor.
Okay, and so if he didn't run, you were gonna add a count, what was the count 6 for?
The count 6 would be part of the plea offer, Your Honor. The count 6 to possession. The plea would be to count 5, the added count 5 on bind over here, a felony firearm, and an added count 6 of possession. People would then dismiss 1, 2, 3, and 4.
Okay, but you've not made a motion to add a count 6, so there's no count 6 then, correct?
Would not be seeking count 6 on bind over, Your Honor.
I believe it's a lesser charge for
Yes.
purposes of a plea.
Mr. Palmer?
Hey, just one quick second, Judge.
Yes. State your name for the record since you're speaking on.
Apologies, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer.
Thank you.
I saw where the breakdown was happening. I thought I could clear it up.
No worries.
You're good.
Thank you, Your Honor. I'm in a little bit of pickle here because obviously I'm standing in for Mr. Freeman. In speaking with Mr. Verser, my understanding from Mr. Verser is that was not his understanding of what the agreement was going to be. His understanding was that he was going to waive up and plea on a felony firearm, which is the new added count 5, and that was it. I don't know where the communication breakdown is. I just don't know. Having volunteered to stand in for this about 15 minutes ago. So I don't know where the communication breakdown is. What I would ask, I guess, is that since it doesn't seem that we're at an agreement here, what I would ask is the court consider adjourning this matter, just because I don't want to have Mr. Verser waive on something that he's not agreeable to. I don't think that's fair to him. And obviously, if there's a communication issue somewhere in there, I think that creates a significant problem. I don't want him to waive a right to which he's entitled if he's not understanding.
I completely agree. Did you have an actual conversation with Mr. Freeman, or was it just this email?
I had that email conversation, and then yesterday I had another email conversation with Mr. Freeman. I have not had the chance to explain it to him in person like that, as he had to leave here today.
Okay, yeah, because if I had to read this email, I would be confused too, because it doesn't indicate here that you're seeking to add a count 6 for him to plead to at the county, at the circuit court. So I can see where this first email, at least, I don't know what the second email at least says, could have caused some confusion for Mr. Freeman, because it's causing some for me too. And so, because we need to properly flesh that out, and your attorney needs to talk to you after having further discussion with the prosecutor, I'm going to find good cause to adjourn this matter.
And I guess I just want to put on the record, Judge, I think that the reason this is such an issue in this particular case is obviously a felony firearm charge requires a mandatory 2 years in the Department of Corrections. The issue is that it's not as if pleading to an additional charge just essentially gets consumed by the felony firearm, because the felony firearm, of course, is a mandatory flat 2 preceding any other count that he's charging to. And so I think not only is there a potential disagreement here about what the charge or what the plea agreement would be, but I'm also concerned because my understanding from Mr. Verser is that he was anticipating doing a flat 2 years, and obviously the addition or addition of any other count, any count, regardless of what it is,
right,
creates an additional amount of time in the Department of Corrections, which is not Mr. Verser's understanding.
Okay.
You want to send this just for a PCC then?
Yes, please.
Then we can do December 15th at 9.
December 15th at 9 for a new probable cause conference. Do you have any questions, Mr. Verser? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Judge. Thank you.
You're all set. Thank you. On the record, in the matter of the people of the state of Michigan versus Diamond Catrice King, file number 23-02869. Counsel appearance.
Jeff Brotto, on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of defendant Diamond King, who is present and standing to my right.
Okay, Ms. King, how are you?
I'm good. How are you?
I'm doing well, thank you. Today's the date and the time that was set for a preliminary examination on carrying a concealed weapon. My understanding is that the parties want to do an unconditional waiver.
That is my understanding, Your Honor.
Yes, Your Honor.
Was there an offer at all?
There was no offer at this time in district court, Your Honor, and negotiations will continue.
Okay, Ms. King, do you understand that you have the right in this matter to have a preliminary examination here in the district court?
Yes, ma'am.
Do you understand the purpose of the preliminary examination?
Oh, yes, ma'am.
Okay, so you have the right to require the prosecutor to put forth sufficient evidence at the preliminary examination to establish whether or not they have probable cause to support that a crime was committed and probable cause to support charging you with the crime. Do you understand that?
Yes, ma'am.
And you wish to waive your exam?
Yes, ma'am.
Okay. And you understand the waiver is unconditional.
Yes, ma'am.
Means you can't change your mind later. This matter will be bound over to the circuit court without a hearing on probable cause here. And your waiver is not based on any offer or any promise. You understand that?
Yes, ma'am.
Is anybody threatening you to get you to waive your exam?
No, ma'am.
Any promises being made to you?
No, ma'am.
Your bind over date's gonna be December 13th. That's the date that they will get the file from the district court over at the circuit court, okay? You do not need to appear in circuit court on that date. The next court date will be a pre-trial. Circuit court, your attorney will be made aware of that. Ms. Donnelly, can you approach so she can sign? Do you have any questions?
No, ma'am. Oh, you signed it. I think, no, I think yeah, I think you did. No.
I can find it. Nice. Okay, bond was set at 200 personal recognizance, and that will continue. Any additional matters for the record, counsel?
Nothing from the people here.
Did the prosecutor have to sign that? Because he didn't.
He does.
Okay, I just want to make sure.
Thank you. Any additional matters, counsel?
Nothing from the people here.
Nothing for defense.
Okay, you're all set, ma'am.
Thank you.
You're welcome. Mr. Broderick, your witness did leave. Is that what you wanted? He left I'm talking the witness that was in the Department of Corrections.
I did speak with him, Your Honor. We did have a plea worked out, which I don't think he would have any.
Okay, so you were okay with him leaving?
Yes.
Okay. I just wanted to make sure so that if not, we contact STF to put him back on, but I'll remove that. On the record, in the matter of the people of the state of Michigan versus Ostiano Young, file number 23-01786, counsel appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. May I get the attorney for Mr. Young?
Okay, Mr. Young is present via Zoom from Eaton County Jail. Today's the date and time that's set for a probable cause conference. The matter is scheduled for a preliminary examination December 7th at 9 a.m. Are we continuing to examine?
We are, Your Honor.
Yes, Your Honor, but there are matters that the people need to address with the court.
Not surprised. You can continue.
Thank you. The defendant has been contacting the victim since the moment he was arrested, immediately after arraignment, as recently as yesterday, telling her to contact prosecutors, contact the police, contact the court, and get him out of there. And she tried. She contacted the police, and she said that they had the wrong man, that it was a skinny white man who attacked her, at which point the police informed her that the entire assault is caught on video from start to finish, showing the defendant in both his black skin and his face. At which point she thanked the police and hung up. The defendant continued to contact her after that point and was desperate to get out of jail, continuously asking her to get him bond, get him out of there. because his bond is 15,000, 10%, which is a low bond, given this matter. It's caught entirely on video. But he also talked about how he would evade the GPS tether if he was released, by saying specifically he'd tell them that he was staying at his uncle's, but he wouldn't actually be living there, because I believe in the supplemental report, it is said it is a GPS tether, so it doesn't matter where the house is, as long as the address verifies. He was also instructing the victim to get a different number, one that is not associated with her, because she is the victim in this case, and he wanted to evade detection. This defendant has a history of failing to appear for criminal cases. This defendant has a history of criminal cases involving domestic violence against this victim. This defendant has a history of contacting this victim from jail when he's in jail for domestic violence cases with this victim. It's actually what spurned the plea to happen in his last domestic violence case with this victim. As a result of all of this, Your Honor, I would ask that we hold a P53 hearing at the day of the examination. Further, I would ask that his bond be entirely revoked pending that hearing, and that all of his jail privileges be revoked pending that hearing. Further, he does have significant contacts in New York. It's where he's been for the last several months, which is why the police were not able to arrest him before this time. And given how fervently he is desperate to get out of jail once he found out there was video, there is a significant flight risk in this matter. I found out about this yesterday when Detective Yeager contacted me about the victim contacting police, which point I found these contacts with the new phone number that the victim called the police from, and I immediately forwarded everything that I had at the time to Ms. Blanchi. But the defendant hasn't left us with many choices here. Thank you.
Ms. Blanchi.
Thank you, Your Honor. I've had discussion with my client contacting the alleged victim in this case. We as defense attorneys, we always ask our clients to follow the conditions of the bond. My client is in jail on the 50,000 surety bond. He has not posted bond yet because he's unable to post bond.
It's actually 15,000, 10%.
10%. Yes, he is unable to post bond. That's why he's still in jail. The bond, the reason for the bond is to secure the defendant's appearance in court. And I think that the bond as it is already doing that. He's in jail. He appears today. He's gonna appear next week. I don't know what. And I don't think that this is the kind of cases that warrant a no bond. The conditions that are put at this time are working, although it's not following the judge's order, which is not to contact the alleged victim. I believe that if he were to be admonished by the court not to contact her anymore, or the jail to block the numbers that he's calling the alleged victim for, I think that would be sufficient.
I do not believe the conditions are working. Further, he was telling her to get different numbers so he could evade detection. He has been actively aware of the fact he's not supposed to contact her, because the first call he made after arraignment was, get new number, one not associated with you. Why? Because this case is about you. He was already confronted with P53 violations in his case in 2022 with the same victim. That's what caused the plea deal in that matter to the aggravated domestic violence. And this is exactly the type of case where bond should be revoked when the defendant has a history of violating court orders and manipulating the victim in order to get cases dismissed, which, by the way, he has successfully done in the past, because there have been more domestic violence cases with his victim than the ones that convictions were gotten on, because he contacted her, told her to call the prosecutors. She did, and the prosecutors handling those cases did dismiss them. I will not be doing such a thing, particularly when such an aggressive assault is captured on video. And frank, Your Honor, when the police got there, She kept falling in and out of consciousness. When she'd wake up screaming, saying, "Please don't let me die." So I believe this is exactly the type of case where that is warranted, given the defendant's actions.
One last thing, Your Honor.
Yes.
My client is the one who's in jail. And I'm not saying that, I'm not taking that lightly. Miss Jackson is the one calling.
That's not possible from the jail. You have to call out. Not in.
She's the one changing the numbers and give the numbers to him.
Okay. I can't really get involved in or opine as to why victims do what they do. This alleged victim giving her number or changing the number or doing whatever her alleged abuser tells her to do goes right to the point of her being under his control and abuse, if that is the case, and the facts that support this case. What I have here, though, is that I arraigned him just 1 week ago on this charge, and I did have a request from the people to put a bond much higher than what I granted. I think he was already on, he has another matter pending, correct?
I don't see anything else.
Well, nonetheless, he appeared and I arraigned him on this on a Thursday, which I would not be doing arraignment, so it must have appeared for something else. Nonetheless, I gave him a 15,000, 10% bond with GPS tether, told him he was not to be within 1,500 feet of Ms. Jackson and that he was not to have contact directly or indirectly. I asked him, did he understand what that meant? I asked him, do you have any concerns about that? He assured me that he didn't. I had his criminal history at the time. I don't have it now, but I do have indications here that this is a matter where he allegedly has a history of threatening or harassing this same victim, and that he does have a prior history of PA 53 violations. It's very concerning that there would be phone calls. I don't know why the people in jail don't know better by now. Like, I don't know why. It gives you, it tells you this is a recorded phone call. That's number one. It advises you. It's not doing that just to do it. It's advising you for a reason. And then, Mr. Pfeiffer, how long have you been at the prosecutor's office?
3 years.
Long enough for word to get around that Mr. Pfeiffer listens to jail calls.
Oh, they know me by name in the jail.
Well, apparently they don't, because for you to call from a recorded call when you know you're under court supervision and to allegedly make the statements that you stated was heard on the recorded call would mean either you're brain dead or they don't know that you listen to recorded calls. One of the two is happening. Nonetheless, I think that there is a flight risk. I think there's an issue that needs to be addressed on the PA 53. You do have the right to have a contested hearing on the allegation that you violated your bond conditions. And making contact with the protected party would be a bond violation, which is a contempt issue. And contempt is punishable with a maximum penalty of 93 days in jail and or $7,500 in fines. Do you understand that, Mr. Young?
Yes, ma'am.
You have the right to be represented by your attorney. You have the right to be represented by your attorney at a contested hearing on the bond violations. You have the right to have the prosecutor put forth evidence to establish whether or support whether or not you did commit the violations that they've alleged. Do you understand that?
Yes, ma'am.
Okay, due to the serious nature of these concerns, we have concerns of witness tampering and or intimidation and possible concerns or threats of evading further supervision when you were supposed to be under a GPS tether if released, and then concerns about potential flight risk out of the state of Michigan, which would also be a bond violation because one of your bond conditions was that you needed to have prior approval of the court before leaving the state. I think it's appropriate that the court revoke your telephone privileges while you're in the custody. That will also include any messaging privileges that you have, video calls that you have while you're in the custody of the Ingham County Jail. The bond will be revoked pending your PA 53 hearing. Do you have any questions?
Oh, man. I do actually. My question is that I don't have any questions, Your Honor.
Okay. Any additional matters for the record?
Not for the people, Your Honor.
No, you.
Thank you. You're all set for today, Mr. Young.
Can I speak to Ms. Wanji in the breakout?
You sure can. You sure can. Are you able to log back on?
Go back.
Thank you, Your Honor.
You're welcome.
And separate from this case, I have had defendants say, I know Adam Pfeiffer is listening to these calls, but, and then say everything. That's about the reaction I got when I heard it.
Same to you.
I will see you next week.
On the record in the matter of the people of the state of Michigan versus Inuyasha Zoo, file number 23-02842, council appearance.
Jeff Rodowitz on behalf of the people, standing in for attorney of record Melanie Smith.
And good morning, Your Honor. Dustin Coons for Inuyasha Vu, who's standing here to my right.
Okay, today was the date that was set for preliminary examination, and you said the prosecuting attorney on this is in trial.
That is my understanding. I was told by Ms. Smith, I'll be honest, I'm not sure if she is in trial or not. I was just asked to stand in today. She did not elaborate on the reason. I believe Mr. Coons has more knowledge on that.
That's true. Mr. Radowitz was looped in later. She was in trial in circuit court this week on the CSC1 case. She knew it was going to go into at least yesterday, possibly today. So even if the trial had finished up, she wasn't going to have much time to prepare for this hearing. She requested adjournment. I was agreeable to that, but we wanted to just address one bond condition in this case.
So bond in this matter is 5,000, 10% with conditions you wanted to address.
Yes, Your Honor, there is, given the nature of these allegations, there's an understandable condition in there that he's not to have any contact with minors. However, my client does have 2 minor siblings. We'd ask for just a slight modification of the condition so that he could have contact with his siblings, even if in a supervised manner. The holidays are coming up. The allegations in this case don't involve a relative or anything like that. So we think it's a reasonable request. My understanding is that people are stipulating to that limited amendment of the bond conditions.
That's my understanding from my conversations with Ms. Smith, Your Honor, is that the people would stipulate to a modification of the bond that Mr. Boone may have contact with his minor siblings as long as it is supervised contact.
Okay, when the defendant was arraigned, the court was aware that there were minor children in the home. And that was part of the order. You want the order amended?
Yes, Your Honor, just again, supervised contact. I don't think,
I don't see how this court can order supervised contact with family members on a holiday, so that's a touchy situation. We can't order a supervised contact with his siblings or any other minors that may be in the home for the holiday. So the bond conditions will stay intact. I think it's for the protection of the public. And of course, the official that did this arraignment had more information before them than I did, as it relates history and risk factors. And it states here, defendant said lives with his mother, works in tech, minor children in the home, will live with his grandparents, and was to provide an address. So measures were taken and put in place specifically even to protect the minors in the home. So those bond conditions will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
no, thank you, Your Honor.
You're all set.
You want a date for the new prelim?
We probably need to get Ms. Smith involved before we do that. She's not here. We don't even know if she's in trial or not. So we'll coordinate an email for that purpose. Okay, thank you. On the record in the matter of the people of the state of Michigan versus Keith Warren, file number 23-03379. You can call your first witnesses after you place your appearance on the record.
Jeff Braddock's on behalf of the people, Your Honor.
Morning, Your Honor. Stephen Mills on behalf of Mr. Warren. Warren is present and standing to my right.
Okay. I previously called this case, asked if there were any matters that needed to be addressed. I was advised there were not, unless that's changed. Please call your next or your first witness.
Thank you, Your Honor. The people would call Mr. Anthony Woods, Your Honor.
Okay. Back on the record, is this your witness?
Yes.
Please state right there and raise your right hand. Take your hands out your pocket, please. You solemnly swear or affirm the information you're going to provide is true to the best of your knowledge, information, or belief.
Yes.
Thank you. You can have a seat there. Okay. There is a microphone that's in front of you. The lady behind you is the court reporter. She has to take down everything being stated here today on the record. So your responses must be loud and clear. They must be verbal. You can't do head nods or shakes, okay?
Okay.
Also, if you don't understand a question, you would let the person asking the question know you don't understand. They can repeat questions if you couldn't hear them clearly. If it's a yes or no, you need a yes or no. You can't do head nods or shakes, okay?
Okay.
If there's an objection, you would stop responding. I'll give a ruling on the objection, then I'll tell you if you can give that answer or not, okay?
Okay.
State your first and last name, then spell both of them.
First name is Shay Anthony, last name Woods. First name is spelled CHEANTAONY. Last name WOODS.
Oh, you can proceed, counsel.
Thank you, Your Honor. Good morning, Mr. Woods.
Good morning.
Mr. Woods, I want to bring you back to the afternoon of November 9th of 2023. Do you remember that date?
Yes, sir.
And where were you on that date?
I was in the driveway of my ex-wife's house.
And what's the address of that?
923 Real Road.
Can you speak up, please?
923 Real Road. And I can't remember her address.
Okay. But is her address in the city of Lansing?
Yes.
In Ingham County?
Yes.
Okay. And why were you there on that date?
I was there to pick up some items for my children.
Okay. And did something happen on that date?
Yes.
What happened?
While me and my ex-wife was outside talking, and he proceeded to come up the driveway and they were just looking. So I just said, "Hey, what's up, dude?" And he proceeded to look at me and say, "Why are you grinning me?" And then I was like, "Nah, I just looked down the driveway." And then he was like, "I'll beat, I'll like cuss. I don't know if I can cuss or
You
not."
can say whatever he said.
So I'll beat your ass. And I was like, basically like, what for? Like, he just seemed like he was just, I don't know, mad for some reason, thought I was looking at him funny. So obviously my kids are and stuff out there. And so I just told him, like, I'm not trying to fight you and I don't know what's going on. Like, I wasn't looking at you funny. Like,
So if I can stop you right there for just a second, Mr. Woods. So you said you were standing out in the driveway of your ex-wife's house, correct?
Yes.
Now, does this, just to kind of give the court an idea, does this driveway only service one home, or what's the layout of
it's a
this area?
shared driveway between 4 homes.
Okay.
Everybody has their like spot by their house, but it's a long driveway which everybody comes up.
Okay, and the individual you, I guess, started talking to, had you seen that individual before?
Yes.
Okay, and do you see, but you say you can't remember his name, correct?
I didn't even know his name at all.
Okay.
Until I got the.
Okay. So you said something to this individual, he said something back. What happened after that?
After that, he just started yelling, and I can't. Also, the lady that was there, I can't remember her name. She started yelling too. But as she started yelling, he went back into the house. He went into the house, received got his firearm.
Okay.
Objection, Your Honor. At this point, it's gonna be speculation at this point. If he's saying what my client went in the house to obtain or what he came to do, unless the client was actually in the house chasing after my client or something like that.
Did you want to respond to the objection?
I can rephrase, Your Honor.
Objection sustained.
So you stated he went into a house. Where is this house, I guess, in relation to where you were standing on the driveway?
So I was in front of my ex-wife's house. If I'm facing out towards the road, there's my ex-wife's house right here. There's another house right here, and there's another house right here. Going into the house that's in front of me on the left-hand side. I'm facing the street. Behind, like inside a gated thing, and then went inside the house.
Okay.
Came back up.
Okay, so you said he went inside the house and then he came back out of the house. Did he have anything with him when he came out of the house?
Yes,
And what did he have with him?
he had a gun.
Okay. And did you see him with that gun prior to him going in the house?
Not at all.
Okay. And so what happened after he came out of the house with the gun?
He came out of the house with the gun and came from behind the gate with the gun already up and pointing towards my head. And said, if you don't back up, I'll kill you.
Okay. And at this point, when he pointed at you, how far from your memory, how far were you from the individual at this point?
5 to 7 feet, maybe.
Okay. And can you, for the court, can you describe, you said he came out with a gun. Can you describe what that gun looked like?
It was a black handgun. I can't tell you specifically, but it was a black handgun.
Okay. And what happened after the handgun was pointed at you?
I put my hands up because my 6-year-old child was probably 2 feet behind me. My ex-wife was behind me also, and my stepchild, my ex-stepchild, she was also there. So I kind of stepped in front of everybody and put my hands up. And if anything did happen, I just wanted everybody to be safe behind me. So I was just trying to protect my family.
And after you did that, what happened?
He held the gun up at me for a few more seconds and then put it down and went in the house.
Okay. And do you see the individual who pointed the handgun at you here in the courtroom today?
Yes.
Can you please indicate where he is sitting in an article of clothing he's wearing?
He's sitting at the desk right there with a black sweatshirt and a gray t-shirt.
Please let the record reflect the witness has identified the defendant.
Any objections to ID?
No objection, Your Honor, to ID for purposes of preliminary.
Identifications noted.
Any further questions at this time, Your Honor?
Cross-examination.
Thank you, Your Honor. Morning, Mr. Woods.
Good morning, sir.
This is a shared driveway between 4 houses you indicated, is that right?
Yes.
How wide is this driveway roughly?
Maybe a little bit more. Can't really tell you.
Closer to 30, isn't it?
From
I'm sorry, just from your ex-wife's house to the house next door. That's about, the driveway expands that full length. Is that fair to say?
Next door is, like I said, her house is surrounded by all 3 of their houses. So everybody's next
It's
door.
one big unit though, is that right?
Yeah.
Like one big house, is that fair to say?
Yeah.
With separate apartments inside the house? Maybe?
Her house?
You're right, I shouldn't say her house. Your ex-wife's house?
No, it's
Hers is just one house, right?
It's just one house, yes.
Now, the neighbor house that we're talking about, that's like several apartments in the house, is that right?
No.
Okay, but it's one big building?
One house, yeah.
Okay, there's not like 4 separate buildings, are there?
No, there's a house.
Okay.
Okay.
So
I don't
between
understand your question.
okay, between these 2 buildings is the shared driveway, is that right?
Yes.
Okay. And it's about 30 feet across, is that right?
I don't think so, but maybe.
Okay.
I don't know.
So you think less than 30?
Yeah, I said around like 15, maybe
15?
20.
Probably 20. Is that fair to say?
Maybe, yeah.
Okay. And on the opposite side of your ex-wife's house, there is a fence, and this is what you're referring to earlier, is that right?
No.
There was no fence. The individuals went into the back of the house, right?
Okay, I think I know what fence you're talking
Okay.
about. There's a fence that it's like a half fence
Mhm.
that separates the front house from my ex-wife, and it's like a little rock thing right there, but it's like a half fence, but it doesn't come all the way out to the driveway.
Okay. So it's beyond the driveway, is that right?
The fence?
The fence compared to the driveway, where the driveway ends and the fence is. The fence is behind the other house, is that right? If I'm walking up the driveway, the route that people were coming up the driveway, okay? You're at your ex-wife's house on the one side, right? They're
Yes.
walking up,
Is that a yes? Sir?
these people are walking up towards you where you and your ex-wife are talking, correct?
Yes.
As they walk up, they walk beyond this building opposite your ex-wife's house. Is that correct?
No, they just walked to the building that they were going to.
They walk to the building that they go to. Is there a fence that they have to walk through?
There's a gate.
Okay, there's a gate that they have to walk through.
Yes.
This gate, can you see through the gate?
Yeah, I can see through.
Is it a wooden gate?
Yes.
And there's panels?
Yeah.
That make up this gate, right?
Yes.
So when the gate's closed, it's part of the fence. Is that right?
No, because it's not technically. I mean, yeah, sure. Yes.
Okay. They walk through the gate at some point, or if I wanted to go into the back into their house, the route they took was through that gate, correct?
Yes.
And then they walk onto the porch, correct?
There is no.
Okay, they walk onto or into the house. Is that right? After walking through the gate.
I assume yes.
Okay. Well, no, that's what you said you saw, right?
Yeah, well, they walked.
Okay.
I seen the door open. Yes. So yeah, they walked in the house.
Just trying to lay out the scene here.
Yeah.
Okay.
I get what you're talking about now.
Okay. So when I'm saying that we've got the driveway and then there's this gate.
Yes.
Right? How much space between the driveway, the side of the driveway and the gate is there?
Barely in the room.
A foot or two?
Yeah.
Okay.
Yes.
When you were talking with your wife, were you in the middle of this driveway?
I was in the driveway, yes.
But you were behind her house, is that right?
Yeah, I was on her side.
Okay. When my client was walking up the driveway now, he was with 2 or 3 other people, is that right?
2 other people, yes.
And as he was walking up, he had like food or something in a bag or something?
I don't recall.
At this time, you and your wife, you guys were having an argument at this point, isn't that right?
No, we weren't having an argument. It's my ex-wife.
Sorry, your ex-wife. You and your ex-wife.
And I was there to receive items for my children. We were having a discussion just about.
Okay, so there was no yelling between you and your wife?
Not at all.
Okay. And as my client walks up, first thing you say to him is, "What are you looking at?"
No, I said, "What's up, dude?"
You say, "What's up, dude?" Just like that.
Yes, just like that call.
Okay. And did you yell this at all?
No, I said, "What's up, dude?"
And why did you say, "What's up, dude"?
Because he was looking at me. I seen him come the driveway, and then he was staring at me. So somebody stare at you out of respect, you know. What's up, dude? So that's all I said to him.
And then he continued walking up to behind to go into the house. Is that right?
No.
He didn't keep walking. Did he skip all the way up?
He stopped and said, "What the fuck are you looking, or what the fuck are you grinning for?"
Okay. And then he just did that for no reason. He just threatened you like that.
Yes.
And you said, "Why are you doing this? I wasn't even looking at you funny." Is that right?
Yes.
All right. That you just prompted yourself saying that from out of nowhere. Is that right? Just because he said, "I'm gonna beat your ass" or something?
No, he said, "Why the fuck are you grinning me?" So I said, "I wasn't grinning you. I was looking down the driveway to see who was walking up. Because I didn't see who it was at first. So I looked down, seen who it was, continued talking to my ex-wife. And then when he got all the way up there to where he could say something, that's when he said what he said."
What does grimming mean?
I mean, I guess like looking at somebody in a mean way.
Okay.
That's how I perceive grooming.
Okay.
And after that exchange, you came towards my client, didn't you?
He said, "I'll be."
No. The question was, you walked towards my client, correct?
I took a step forward because my kids were there. So
You took a step forward towards my client. Is that correct?
I didn't take a step towards him.
Oh, did you take a step back?
No, but I wasn't taking a step towards him.
You didn't take it. You did not take a step towards him. Is that correct?
No, I wasn't
Okay.
taking a step forward.
And then my client walked to the back of the house, right?
No,
After he stopped and the two of you had some words, he then walked to the back of his house. Is that right?
He walked through the gate.
So he walked through the gate. Is that correct?
Yes.
Now, at this point, you said that he came back out at some point, right?
Yes.
Now, isn't it true that you ran at him, didn't you?
No.
No, you just happened to be, what did you say? 5 to 7 feet away from the fence when my client came back out with a gun?
Yeah, I was 5 to 6 feet. away.
Okay, so you did approach the fence, didn't you?
No, I did not.
You magically apparated in front of this fence, didn't you?
No, I did not.
Okay,
You're twisting words, man.
well, you were 5 or 7 feet from my client when he came out, is that right?
No, he walked up the driveway, right? I'm already in one spot. He went in the house, grabbed his gun, came out. I didn't run at, why would I run at somebody with a gun?
You indicated that he was at or near the gate of the fence when he came back out for the second time with a gun, correct?
He only came out one time.
He was out there that one time with the gun. He was at or near the fence, is that correct?
Yes.
Okay. And at that point, you were 5 to 7 feet away from each other, right?
Yes.
So you would have had to close that distance, correct?
I did not close distance when he had a gun pointed at me. That's not smart of somebody to do.
You closed that distance though, didn't you? You came towards the
No, I
property.
did
Your Honor,
not.
objection asked and answered at this point.
Thank you. Objection sustained.
Thank you very much. Was the weapon fired?
No. It was aimed towards my head. And I have to protect my.
Objection, Your Honor, non-responsive.
There's no question. You can only respond to a question, okay, sir?
Yes, sir. Or yes, ma'am.
You don't have no further questions this time. Thank you.
Redirect.
I think just briefly, Your Honor, so Mr. Woods, when the first interaction with this individual took place, how far would you say you were from the fence or the gate that was in question here?
Maybe around 8 feet.
Okay.
9 feet. I took 2 steps forward. After.
Okay, and then after you didn't move between that time, well, other than the couple of steps you just made, you didn't move between that time and when the individual came out with the firearm, correct?
No. Well, yes, I did move because when he came out with the firearm, I had to step. My kids were there. To me, I stepped in front of my kids. That's what I was doing when I took the 2 steps forward.
No further questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Thank you, Mr. Woods. You may be excused. You can call your next witness.
People have no further witnesses, Your Honor. The people rested.
Any witnesses?
No, thank you, Your Honor.
Argument.
Thank you, Your Honor. The people would move that this be bound over as charged. Well, we would move that count 1 be bound over to the circuit court as charged. People would also move that an added count 2 of felony firearm be bound over as well. We heard testimony here today from one witness, Mr. J. Anthony Woods, who stated that on the afternoon of November 9th, 2023, at his ex-wife's house, which he could not remember the exact address of, but he stated was on Rio Road in the city of Lansing and Ingham County, that he was there speaking to his ex-wife when he saw some individuals come up the driveway. He asked one of those individuals, or just said, you know, what's up to one of those individuals, which caused an altercation to occur between Mr. Woods and those individuals. Mr. Woods then testified that one of those individuals who he identified here as the defendant today walked into the house that was in, I believe he said, front to his left, if you're facing the road, in front of his ex-wife's house, and came back out of that house with a firearm. That individual then pointed the firearm at Mr. Woods, which caused Mr. Woods to fear for his safety and that of his ex-wife and his child, former stepchild. And that after that, I believe he also testified that something was said at that point, though I cannot remember exactly what. But then he and the situation ended from there as the individual put the handgun down and everybody left. So based on that, Your Honor, I believe that the people have met by probable cause evidence that the defendant, identified later by police, Mr. Keith Warren, who was identified here today, did either or did cause a reasonable person to fear or apprehend an immediate battery when he pointed the firearm at Mr. Shea Anthony Woods, that Mr. Shea Anthony Woods did reasonably fear an immediate battery, that assault or fear of a battery was committed with a firearm, which by definition would be a dangerous weapon. And with that, people also believe they've met with probable cause evidence the elements for the added count 2 felony firearm. And so the people would ask that this be bound over as charged to the circuit court with the added count 2 of felony firearm, Your Honor.
Mr. Meltz.
Thank you, Your Honor. I think, and obviously it's more of a matter for jury, but I think there's serious concerns regarding some of the statements regarding credibility in this matter. We know the driveway is 30 feet across. We know that Mr. Woods was on one side of the driveway.
How do we know it's 30 feet across?
That's roughly what he said. He said it was roughly 30 feet across.
So he says 15 and.
He said, oh, I'm sorry, not 30, you're right. Between 15 and 20, somewhere in there. He was on his side. He said that he wasn't on the driveway. He was behind the house with his girlfriend. 15, 20 feet away is where the fence is. And I know I belabored the point, but I felt like he was really tripping over his own words at a certain point where he couldn't account for how he got all the way over there when he said he was 5 to 7 feet away. That all aside, Your Honor, I believe that this court has to dismiss this case at this time. I would direct the court to Michigan Court Rule 11.3 regarding the definition of a pistol. And I'll read that, Your Honor. Pistol obviously is a firearm. Firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of explosion. By action of explosion is key word there. Your Honor, this was an airsoft gun. Actually, I don't know what it was because the people didn't put any evidence whatsoever whether or not this gun, when there were police, when there was other witnesses, when there were plenty of evidence there, they didn't present the evidence that this was a gun by explosion. They presented nothing to this court just because and it's a necessary component to felonious assault, especially to felony firearm. The people cannot just sit on their haunches and just expect this court to expect or anticipate or assume all of these things. And it'd be ridiculous to do so. If this was a toy gun, would not be felonious assault. If this was an airsoft gun, not felonious assault. If this was a paintball gun, not felonious assault. Because the people have charged us with a pistol. Your Honor, this court cannot bind over. I'd ask that the court dismiss this case in its entirety at this time. Thank you, Your Honor.
Mr. Barlett.
Just one second.
No problem.
Your Honor, at this time, I believe the people have met their burden by probable cause evidence as we had testimony from Mr. Woods that what he observed was a pistol or a firearm. And as for.
Did he describe anything?
Yeah, he described it as a black handgun, Your Honor.
And how do we know? Did he inspect it? Did he get close enough?
I believe he said he was 5 to 7 feet away, Your Honor, so he could see what was being pointed at him.
I recognize we see that he was pointing at it, but how do we know that it's a pistol? Which is what the allegation is.
I would rely on the testimony of the witness, Your Honor, that he could identify what a pistol was.
From 5 to 7 feet by looking at it, correct?
Yes.
Okay. Any additional?
No, and as for, I guess, the added count too, in relating to that, Your Honor, under was it MCL 750.227B, which would be for felony firearm pneumatic guns are also covered under that statute. So I believe whether it was a firearm capable of expelling a bullet or an airsoft gun, count 2 would be met by the fact that it was a firearm, Your Honor.
Thank you. Okay, today was the date and the time that was set for a preliminary examination. The burden is on the prosecutor to establish probable cause of the crime was committed and probable cause sufficient to charge Mr. Warren, with the crime. This is not a trial. They don't need to prove each element of the charge beyond a reasonable doubt. This is just the time for them to establish that they have more than mere suspicion that the alleged crime was committed. So we have the testimony of one witness here, the alleged victim of Shay Anthony Woods, who testified that on or about November 9th, 2023 at the area at or near 923 Rio Road. He was not 100% sure of that number, but it was located in the city of Lansing, Ingham County, state of Michigan, making venue appropriate before this court, that he was in the driveway of his ex-wife's house. He said collecting or picking up items for his children, having a discussion with his ex-wife when he stated that the person he identified in court as the individual he came in contact with, the person identified as the defendant in this, and not by name, but by face, approached and asked, "Why are you grooming me?" The court asked him, "What does grooming mean?" The witness said he believed it to mean, looking at someone angrily. The victim stated that he indicated that he wasn't looking at the defendant or the person he identified in court as the defendant, that the individual began yelling at the victim, and that individual left and retreated into a home that was on the left side. He stated that the individual returned and came back out with what he described as a gun, and that victim stated that he didn't see or observe the individual to have a gun prior to going into the home. He described a black handgun. He said that the defendant, or the person he identified as the defendant, to later point the gun at his head. He was about 5 to 7 feet away from the suspect at the time of that interaction. The people are seeking bind over on count 1 of assault with a dangerous weapon, felonious assault, and they want to add a count 2 of felony firearm. Assault with a dangerous weapon will require the people to be able to prove at trial each element beyond a reasonable doubt. First, the defendant either attempted to commit a battery upon it, in this case, Mr. Shay Anthony Woods, or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of a person or something closely connected with the person. Second, that the defendant intended either to injure Mr. Shay Anthony Woods or to make Mr. Shay Anthony Woods reasonably fear an injury. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought he had the ability. And fourth, that the defendant committed the assault with a dangerous weapon. A dangerous weapon is an object that could be used in a way that is likely to cause injury or serious injury or death. The testimony or of the victim, Mr. Shay Anthony Woods, is that he saw a firearm, a black firearm that he described to be a pistol, pointed at him 5 to 7 feet away. He did not inspect the vehicle, that apparatus or that device to ensure that it was indeed a pistol or if it was an airsoft weapon. However, that was what he believed he observed. The court is clear that this is not a trial, and it sounds like there's a question of fact as to whether or not there was, in fact, a firearm present. And so, with that being stated, I have IT remoting into my computer right now while I'm trying to read jury instructions. Give me just a moment. Okay, and so the court is satisfied that there's sufficient probable cause as to count one, assault with a dangerous weapon, that being felonious assault, and that will be bound over. And the people are requesting to add a count two, a felony firearm, alleging that the defendant used a firearm in commission of the felony assault with a dangerous weapon. The court is satisfied based on the testimony that there's sufficient probable cause, and that any further evidentiary issues or question of facts should be decided over at the circuit court. And so count two will be added and bound over to accompany count one. Your bind over date is going to be December 13th. That's not a date you need to appear in court. That's the date the circuit court will get the file from the district court. Your next court date will be a pretrial in circuit court. Mr. Milks will be made aware of that, okay?
Very good. Thank you, Your Honor.
Okay?
Yep.
Okay, do you have any questions?
Not at this time, Your Honor.
Okay, your bond was set at 2,000 personal recognizance with a no contact order for J. Anthony Woods. It says you not to be within 2,000 feet of wherever he is. I don't know how that's possible.
He indicated he doesn't live there. I think he said that was his ex-wife's house. He was there just to exchange items with his ex-wife or something. So I don't.
I understand that, but his kids live there. Means he would frequent that area, no?
My client also doesn't live there though.
Oh, your client doesn't live there. Okay, that makes
No, I'm
sense.
sorry. My client doesn't live there. I don't believe Mr.
Oh, okay, that makes sense. Okay, sounds good. Any additional matters for the record? Bond will continue.
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
You're all set.
Thank you.
That's good, yeah. Yeah. All right. Really need it all. Appreciate it.
All right, who's on phone number ending in 6495?
Yes.
Who are you?
I'm Nancy McGuire. I did not go to court on the 27th for my rent. I called my landlord and she's not answering the phone. I called her 20 times and I wanted to see my outcome on that because I only owe $119. They said I owe $1,200.
Okay, if you didn't come to court, then you likely got a default judgment because you had to appear in court. So you need to call the clerk's office, not your landlord, and ask to file a motion to set aside default.
I need to call the court office.
Yeah, you need to call the civil clerk's office at the court.
Okay, what is that number? Because I was in the hospital. I was in the hospital and I just got out of treatment and they moved me to a 3-quarter housing.
I got it. 517. 483. 4426.
Thank you.
You're welcome. Okay. On the record, in the matter of the people of the state of Michigan versus Fair and Burt, file number 22-02170, Councilor Pants.
Jeff Reynolds on behalf of the people, Your Honor.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Baron Burt, who is seated to my right. I will note I'm filling in for her attorney of record, Steve Freeman.
Okay, and so how are you, Ms. Burt?
I'm good.
Okay, I have a plea offer here. It says that the people are offering for Ms. Burt to plead guilty to count 1 and the people will dismiss third offense notice. There is a Killebrew, which is a sentencing agreement about how you're going to be sentenced. It says for fines and costs only. That's accurate?
That is, Your Honor.
Yes, Your Honor.
So you want to accept that offer, ma'am? Okay, please raise your right hand and you can stand up. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. You have an advice of rights and plea information sheet here. There's a signature. Is that your signature?
Yes, Your Honor.
Did you read this document?
Yes, Your Honor.
Do you understand the rights listed here?
Yes, Your Honor.
Do you have any questions about these rights?
No, Your Honor.
And are you willing to give up each of these rights here today in order to enter a guilty plea to count 1?
Yes, Your Honor.
You understand that you have the right in this matter?
Yes, Your Honor.
I didn't say what the right was. I stopped because I just realized the jail is in here and I don't know why. Let me remove that. Okay. You have the right in this matter to proceed to a jury trial? You understand that, right?
Yes.
You understand that at your jury trial, you have the right to remain silent and not have silence be used against you. You have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at your trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to confront in court and cross-examine or question any other witnesses and your accuser if called to testify against you. You have the right to call your own witnesses or present evidence at your trial that you believe further defense to the charge being brought against you. You understand all of those rights?
Yes, Your Honor.
Anybody threaten you to give up those rights?
No, Your Honor.
Okay. Are you currently on probation or on parole?
No, Your Honor.
Okay, what are you being held on?
Method of charge.
Okay, so you have another matter pending? Okay,
I think technically she's serving sentence.
okay, serving a sentence on another matter, okay,
Yes.
okay. You understand that a guilty plea could result in a conviction that may need to be reported to a future job?
Yes.
You understand that a guilty plea also could impact travel or immigration status you may be seeking?
Yes.
Do you have another matter pending? In this court? Okay. I didn't
I
just.
believe it was a sentencing.
That's what I thought. Okay, I was, did I just see you last week? Yeah. Okay, very good. Okay, sounds good. Okay. As to the domestic violence, you understand that a guilty plea could affect travel or immigration status that you may be seeking?
Yes, Your Honor.
Okay. As to count 1 of domestic violence, how do you plead?
Guilty.
A factual basis, please.
Certainly, Judge. Ms. Burke, I'm going to take you back to July 17th of last year, 2022. On that date, were you at or near the intersection of southbound US 127 and westbound I-96 interstates?
Yes.
And that location, that intersection is within the city of Lansing in Ingham County in the state of Michigan.
Yes.
And at that time and at that location, you were riding in a vehicle with an individual by the name of Luis Perez Revolta. Is that right?
Yes.
And that individual, Perez Revolta, is an individual with whom you either had or currently have a dating relationship.
Yes.
And while riding in that vehicle, Mr. Perez Revolta was driving. Is that right?
Yes.
And you were the front seat passenger?
Yes.
And at some point during that interaction, you struck Mr. Perez Revolta. Is that right?
Yes.
You slapped him or hit him or something
Yes.
in the right cheek.
Yes.
And you did not have justification for doing that. Is that correct?
No.
Thank you, Your Honor. I have no further questions.
Okay. That wasn't in self-defense, correct?
Correct.
Okay, any questions?
No further question, nothing from the people, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea and find your plea you made freely, voluntarily, and intelligently. How long is she in Clinton County on sentence for?
Judge, she's serving 180 days. My understanding, she got there October 8th, I believe. She, at that time, had roughly 40 days of jail credit, so she's about halfway through the 180 days, give or take a week or two.
You can make allocution. Sentencing.
Thank you, Your Honor. I'm asking that the court follow the agreement. There's a Kilbrew agreement in this matter for fines and costs. Certainly, Ms. Burt is trying to move on with her life. I'm just asking the court to follow the agreement.
Okay, that's good. Doesn't make sense to put her on probation if she's gonna be in jail for another 100 days or so.
For the record, Your Honor, I apologize for just the other half of that is I believe there's a 24-month probation after the 180 days.
Okay.
And that's what.
Does your office have contact with the victim? Because when there's a victim, I have to set it for a sentencing.
So we did, Your Honor. He was the gentleman I spoke to earlier today. I advised him of the potential for immediate sentencing. And obviously he left the room, so I believe people would have no objection to immediate sentencing.
Okay, sounds good. Sentence is $75 crime victim rights with $50 state minimum cost. We'll refer that to collections, and once you are out of custody, you can make that payment, okay? Any questions? Any additional matters for the record?
Nothing from the people, Your Honor. I have nothing further, Judge. Thank you.
You're all set, ma'am.